Senator Warden.
Thank you, Mr. Chairman. I wanted to start by saying you've really done some remarkable work, Chairman Gensler, over the last 4 years. You've taken on important fights for taxpayers, for consumers. You've shown some real backbone, something that I hope would act as a model for some of the other leaders of our regulatory agencies. You've laid out a roadmap for the CFTC to follow in the years to come, and really done a great job in identifying priorities, where we should be, what we should do. But I have a specific follow-up question to what you've laid out. And that is, as you know, the CFTC has been under sustained pressure to delay implementing the rules that you have already worked out. And so my question is, could you comment on how important it is to stick to the timetables that the CFTC has laid out?
Thank you for that question. I think it's important, one, because 8 million people lost their jobs. Two, there's still risk in the financial system, and there will always be risk in the financial system. And if we're going to truly end too big to fail, we need to cover and finish off these transparency and risk reduction things. And then three, sometimes a deadline just helps people come into compliance. You were a professor, you know that sometimes having those deadlines, people, and so we'll work with market participants to smooth the transition and where appropriate, use our tools to give them some relief, but stick to the deadlines.
Good. Thank you very much, Mr. Chairman. So I wanted to ask both of you a question about enforcement. We've spoken individually about enforcement multiple times. And recently, Chair White, you announced that the SEC will be requiring admission of guilt in more cases. I think that's a powerfully important step. It shows real toughness in your enforcement strategy, and that will help build leverage even when you end up with a settlement. But when I talk about the importance of being willing to take large financial institutions to trial, people tell me, well, it's a real problem because the agencies don't have enough resources in their enforcement divisions, and they'd have a tough time going up against big Wall Street corporations. So can each of you discuss whether you have the resources and the importance of resources in having an effective enforcement strategy? Chair White, might I start with you?
Yes, there's no question that additional resources are essential to our successful enforcement strategy, including the change that you're referencing. One of our specific requests in the President's budget is for additional trial attorneys. And we can't judge at this point how many additional trials we're going to have, but we already don't have enough. We have to be prepared to go to trial. We are prepared to go to trial. I'm really proud of frankly, the record that the SEC has had in trials. I mean, it's like it's about an 80% as to when you see it from a defendant's point of view. One of the things, we need resources across the board for many other things as well. And our budget situation is we're budget neutral, deficit neutral. And I would certainly hope that we could get that funding, and it really is essential to that strategy.
Thank you. Chairman Gensler?
We have not shied away from bringing cases against large banks, against exchanges, and sometimes if they don't settle, going straight into court. We're proud of that, but I would say our enforcement resources are tiny compared to the size of the markets. And the American public put $180 billion into AIG. That's 600 times what the President asked for funding for our agency. And our enforcement folks are only about 150 of our people. And unfortunately, we're trying to make the best decisions, but often we have to delay justice because we don't have the right resources.
Well, that's a very important point. Thank you very much. It seems clear that if Congress wants to have a tough watchdog, it needs to make sure that the dog hasn't been starved. So I appreciate your comments on this. I have one more question, and that's for you, Chair White. One share, one vote has long been a bedrock principle of corporate governance. In recent years, however, a number of companies, Facebook, LinkedIn, Groupon, have given special insiders voting powers that are far greater than those available to the investing public. This can have short-term benefits, of course, in some cases, but it undermines the basic concept of ownership and says, in effect, that some inside owners can help themselves, even if it's at the expense of other outside owners. Now, last October, the Council of Institutional Investors wrote letters to the New York Stock Exchange and NASDAQ requesting that they prohibit companies seeking an initial listing from having unequal voting rights. I wrote a follow-up letter to the exchange last month. I haven't gotten a very encouraging reply. Chair White, do you support the principle of one share, one vote? And if so, do you have a position on whether or not the exchanges should require it?
I think it's that is the voting rights and the voting rights structure is kind of dictated by state law, actually. But and the SEC years ago actually attempted to act in this space in that direction, but there was an authority issue that the court overturned the action that the SEC did take. So if there is to be movement in that direction, and I can't prejudge it because I'd have to judge it when it comes in, it would come from the SROs. I mean, in terms of what, the legal decision, I think, as to the SEC's authority would not certainly necessarily preclude the SROs. They do have a rule that prohibits disenfranchisement, but that's different than what you're talking about.
No, I understand that. And the question I was asking is basic support for the idea of one share, one vote.
Well, I certainly support shareholder franchisement to the degree, to the most significant degree possible. But it isn't an issue where I think the SEC can act on its own.
I understand that limitation. I apologize for going over. Thank you, Mr. Chairman.